the topic. Let's turn to the topic. Today it's Article 4 of Protocol number 4, the prohibition of collective expulsion of aliens. I was wondering a little bit when I've been invited on this topic to speak on this topic, because it's not of that much practical relevance for judges. Why it is so, we will see later, I hope. However, the topic was addressed yesterday already in the presentations, and we're all aware of the setting, why it is an issue, also in the jurisprudence of the European Court of Human Rights, because we experienced the mass influx of refugees in the years 2015 and 16. Later on, we have this, what yesterday was described as instrumentalization of migration, especially by Belarus, where situations occurred at the border in the east, the external EU borders in the east. We're all aware of this, the so-called pushback problematic, which was addressed yesterday too. And finally, of course, since 1 year now today, we have the war in Ukraine, the Russian aggression, and the influx of refugees from Ukraine. More than 8 million in total left the country, and about 1 million arrived, for example, in Germany. So these situations that have occurred, and especially the situation of pushbacks at the border in the 2015-2016 crisis, refugee crisis, the high number of refugees who came through the Balkan route, but still today, the so-called Balkan route gets more and more important, and it's used by a lot of refugees to reach Central Europe. So it's a pending issue. It's very actual, and we now want to see how the European Court of Human Rights deal with this question, the question, the prohibition of collective expulsion of aliens, which is much related to the question of pushbacks, which we will see later, which is, of course, you all know, but we will see how far it is related. So what you will expect in the next half hour, a short outline. Before we I want to explore the more recent jurisprudence of the Strasbourg Court. I thought it would be helpful to recall the notion of collective expulsion. What is it? What elements does it have? What's the protection level of it? And then we will analyze the three mentioned judgments which have been suggested to discuss more in detail. And I will try to discover where are the new elements in this judgment. Is there in the development, and if so, in which direction? Finally, I have drawn up some points for discussion. This is just a suggestion. Of course, you can ask any question, make any remark, or involve any or introduce any other topic you like. Let's start with the concept of prohibition of collective expulsion. What is it about? Let's have a look at the legal framework. I think first we have to mention what is the situation of the protocol within its relation to the convention itself. We can see in Article 6 of the Protocol number 4 to the European Convention of Human Rights that the provisions of the protocol shall be regarded as additional articles to the convention. So it's on a kind of same level, at least materially spoken. And all the provisions of the convention shall apply accordingly. So what does the law say about prohibition of collective expulsion of aliens? Nothing but that. Article 4, Protocol number 4. Collective expulsion of aliens is prohibited. So which elements are described by law? The expulsion. What is an expulsion? We will have a look at this. the element of expulsion. The expulsion must be collective. When is an expulsion collective? And what does the prohibition, what is the content of the prohibition? What kind of rights result from this prohibition, positively speaking? So when we look at the definition of collective expulsion in the jurisprudence of the Strasbourg Court, it is described as any measure compelling aliens as a group to leave a country, except where such measure is taken on the basis of a reasonable and objective examination of the particular case of each individual alien of the group. I have quoted here one judgment where this has been referred to by the court. So a group of aliens, a measure which compels this group of aliens to leave the country, is a collective expulsion, but only if there is no individual assessment of or examination of each individual case. So this is the main concept of the prohibition of collective expulsion. So the purpose of this provision is, and the right resulting from it, is to prevent states from being able to remove a certain number of aliens as members of a group without examining their personal circumstances and therefore not enabling them to put forward their arguments against the measure taken by the relevant authority. So this is the main task and the main direction of it. What other elements do we have? It is not relevant whether the aliens reside lawfully within the territory of the member state or even outside the member state, what we will see later, and applicable also for stateless persons. This is stated in the Georgia versus Russia case. This is a case of collective expulsion of Georgian nationals from the Russian Federation in 2006. And here the court established a violation of Article 4 of Protocol number 4. And also individual court decisions in the case, court decisions by the Russian courts, were issued in each of the cases. It was because of the high number of expelled nationals made it impossible to assess them individual. That's how the court assessed it. So there were individual decisions, but the mere number of cases made it, to the view of the court, impossible then that they could be assessed individually. This was the Georgia versus Russia case. So a violation of the provision was established by the court. Another element, I call it the territorial scope of the provision. It's related to the competence. The court calls it the jurisdiction, which is a little bit misleading. I would rather say it's the competence of the states for measures carried out in the high seas by European states in order to prevent undesired arrivals on their shores. We all know the cases, the migrant route via the Mediterranean Sea, where we had a lot of incidents, a lot of refugees die every year on this route. So it's a much frequented route. And so there were a lot of cases, I have quoted some here, where vessels were stopped on the high sea in the Mediterranean. And the refugees, the passengers on the vessels were returned by mainly Italian, but we also have Greek cases to Turkey, Italian to Northern Africa, were returned back there. And here the court said that the territorial scope of the provision is not limited to the territory of the member state, but also outside the territory, for example, the high sea, which does not belong to the state territory, as long as the states exercise authority, their competence to exercise measures as described. So this falls under the territorial scope. It must not necessarily be on the territory of the member state, which might lead to some, I will later raise the question, what does it mean to the concept of expulsion in the national systems, which is mainly related to cases where an alien resides or has resided in the territory of a state and who is later expelled. That's the main national concept we have so far. But the Strasbourg Court extends it also to outside the territory of the state. So what does it mean to these national concepts? And we have a case pending at my Senate. I will come back to this later in the discussion. I have suggested it for the discussion. We can talk about if there's an extension of the concept of expulsion by this. So what is the scale? How to assess the possible violation of the prohibition of collective expulsions? You have to ask the question, are there sufficient guarantees demonstrating that the personal circumstances of each of those concerned had been genuinely and individually taken into account? What we will see later, this is the main content. It's more a procedure, the content of the right or the prohibition and the right which results from it. It's mainly a procedural thing. It's only a question if the individual circumstances are assessed and have to be recognized in a way. So which factors speak against such against this? This can be instructions for operations by political authorities, or in case when all aliens are required to attend the police station at the same time, when identical orders were issued to all individuals of the group, members of the group, if there's no access to lawyers, and there's if there are no or incomplete asylum procedures. This is also in the Chonka case versus Belgium mentioned. The thing which is a little bit strange, instructions for operations by political authorities. That means that the state authorities follow a specific policy in treating these group of people, in the treatment of the group of these people. And we can also find it, for example, in MK versus others and others versus Poland, a decision of July 2020. And this was a repeated refusal at the Polish border guards on the border with Belarus to admit the applicants of Chechen nationality. And in this case, MK and others versus Poland, the court established that there is a violation of Article 4, Protocol 4, by the decisions refusing the applicants entry to Poland and not being taken with proper regard to their individual situation. Of course, that's what we have seen. That's the main element, the individual assessment. And that's new from this jurisprudence. These measures had been part of a wider policy of refusing to receive asylum applicants from person presenting at the Polish-Belarusian border and returning them to Belarus. So this is also, if such a policy exists, that's an indication that there is no individual assessment, that this might end up in a violation of the prohibition of collective expulsion of aliens. But the mere fact that many identical orders were issued does not necessarily establish a collective expulsion. You can see from MA versus Cyprus, which I have quoted here, as long as the general circumstances display that an individual assessment has taken place. So this is what you have to look for. Has it really taken place, the individual assessment? It does not matter that there are formulaic orders and in identical terms without reference to previous decisions regarding the asylum procedure. This does not itself indicate as a collective expulsion. And also, in addition, in the case Sultani versus France from September 2007, a rather early decision of the court on this provision, the mere enforcement of a deportation order or decision, even when it was in a larger number, they were issued in large numbers, does not establish a violation. So if there has been an individual examination of the case, and later on the decision resulting from this examination is enforced in a large number of cases at the same time, for example, putting the people on a plane, let's say 100 of them, putting them in a plane and send them back to a specific country of origin, the enforcement of the decision in the large number does not establish a violation of the prohibition of collective expulsion. And maybe in addition on this, the question of this individual assessment, how individual must it be? In the case Calaifa and others versus Italy from December 2016, the court said that Article 4 of Protocol 4 does not guarantee the right to an individual interview. It's not necessary to have an individual interview in all circumstances. The requirements are satisfied where each alien had a possibility of raising arguments. So you can see it's a difficult line to draw. There has to be an individual assessment, and this is the main content of the provision. But if cases are dealt in the same way, and even if you have individual decisions and orders resulting from this, it does not necessarily establish a violation of the provision. So what does the term expulsion mean? The interpretation by the court. The term expulsion means that it's inclusive of any measure that has the effect of driving away certain aliens from a place, thus covering refoulement at the sea. This I have already mentioned, and this is one of the leading cases, ECHR and others versus Italy from February 2012. An expulsion contains also other activities aimed at protecting European borders, such as accelerated returns procedures following a failed attempt to irregularly enter the territory or a refusal of admission at the terrestrial checkpoints. Sharifi and others versus Italy from 2013, and also the already mentioned Calaifa and others versus Italy judgment. So one can sum up what is expulsion? It's a collective rejection of aliens attempting to enter the state territory at borders or from the high seas. The scope is wider, and this I already have mentioned. The scope is wider than the national understanding of expulsion, which require an expulsion from inside the state territory. So this is on the term expulsion. And so the main content of this right is it's more a procedural guarantee, and it's applicable irrespective of the nature of the destination of country of origin, the country of origin or the destination country, the destination for the expulsion, where shall it end? That means that it does not require that the person concerned has a risk of ill treatment when returning to his or her country of origin. This is not an element of the prohibition of collective expulsion. And as I said, the main content is just the mere fact of collective expulsion without individual assessment, which violates the provision. So I will end up here with a description of the elements of the right of or the prohibition of collective expulsion and the rights which result from it. And I will turn to the cases that were suggested. And I would start with the case HK versus Hungary. The facts were that the applicant, who was an Iranian national, after crossing several countries through the Balkan, so-called Balkan route, arrived at the Serbian-Hungarian border in May or June 2016, where he was waiting for the admission to the Hungarian transit zone. That, as you know, the Hungarian side has set up transit zones where the refugees are supposed to cross the border, where they are registered, where they have the possibility to file a protection application. But there's they have to wait on the Serbian side to enter these zones. So they were kind of traffic jam on the route, and while waiting, there seems to be an informal procedure that people, here in this case, it was called an Afghan man, who lists up the people arriving there, and by this allow them to enter the transit zone at a specific time. So he was registered on this list, and he tried to enter Hungary several times illegally. So he proceeded by himself, but he was removed back. And then on such attempt, on the 3rd September 2016, he was stopped together with other Iranian nationals in a Hungarian village several kilometers inside Hungary by Hungarian police officers, and he was taken to a minibus with 2 other individuals waiting. In the police station, the applicant allegedly expressed that he wanted to be a refugee in Hungary, so some kind of protection application maybe. But he received no information or documents and was driven back to the border fence in the minibus, where he and the other individuals of the group were then forced to walk back through the gate in the border fence in the right direction of Serbia. And according to official statistics, 76 individuals were removed from Hungary in that way on that date, the 3rd September 2016. After treatment in a hospital in Serbia, because he also alleged that he was beaten by the border guards and was injured, then he was treated in a hospital in Serbia, and then he was finally allowed to enter the transit zone on the 26th of September 2016, where he applied for asylum. He was transferred to an inland reception center, but before the negative decision of the Hungarian authorities in February 2017, he left for Germany, where he currently resides. So this is the case, the facts of the case. The decision, the court, by a judgment of the first section in September 2022, established a violation of Article 4, Protocol 4 itself, and a violation of Article 13 of the Convention in conjunction with Article 4, Protocol 4. And the main reasoning was, in paragraph 9, that based on the undisputed escort of the applicant by Hungarian officers to the external side of the border fence, the court considered that the removal amounted to an expulsion, the one element of the provision, expulsion. So it was an expulsion in the sense of Article 4, the way he was transferred back to Serbia. And regarding the other element, the collectiveness of the expulsion, the court referred to Shasad versus Hungary, where the court, I would say, first assessed the situation at the Serbian-Hungarian border, where just look at Shasad, where the court found that the removal in Shasad, the court found where the removal based on the same national Hungarian provisions they were referring to, the Hungarian officers, that this provision violated Article 4, Protocol 4, because it had been carried out in the absence of any decision and examination of the applicant's situation, no individual assessment. And the court referred to that the only means of legal entry at the two transit zones could not have been considered to be effective in a view of the limited access. So there was only a daily quota how many refugees could enter the zone. And there was a lack of any formal procedure accompanied by appropriate safeguards governing the admission of individual migrants. The applicants first had to register on the informal waiting list and then potentially had to wait several months in Serbia before being allowed to enter Hungary. So this situation established, in the view of the court, the collectiveness of the expulsion. It is an expulsion and it was collective because of these elements. So what is new about this? The court referred itself to the Shahzad jurisprudence, the previous, and here in this case, other than in Shahzad, the applicant was on the waiting list to enter the transit zone. In Shahzad, this was not the case. And then later, he was allowed, after some failed attempts, he was admitted to the transit zone, and he finally applied for asylum for international protection. This was different to Shahzad case. But however, on the specific date of the legal entry, remember, the applicant tried several times, made several attempts to enter Hungary, but was returned back. But in this decision, the court referred only to the specific date, which was raised by the applicant in the case, the 3rd September 2016. And on that date, the court said, he had no information as to whether or when he would be able to gain access to the asylum procedure. The mere fact that he later managed to enter the transit zone could not make his removal from Hungary on this specific date compliant with the convention. Having regard to the information in its possession and nothing that the government did not put forward any argument demonstrating that at the time of the applicant's removal, the procedure for legal entry had been effective, the removal was of collective nature. Interesting point. Usually you have the situation that also in this case, the refugees try several times to enter and to proceed on their way to Central Europe. But here in this decision, the court focused only on the one day where he was picked up by the Hungarian officers and returned to Serbia. Despite the fact that he later on had the chance to enter the transit zone, to make an application, and so on. So the court said at that date there was a violation. We will see in other cases, the court had a different view on this. So we come to the next case. Let's have a look at the time. I have to rush. Here are the facts. The case takes place in Northern Africa. The two applicants were living in Tangier, Morocco, in Morocco, without any legal status. In September 2016, together with approximately 150 other people, they attempted to storm the border fence at Ceuta to enter the Spanish territory. You all know the setting, the Spanish enclave in the Moroccan territory, or surrounded by the Moroccan territory. And so that he was a member of a group of 150 who approached this fence and tried to enter the fence. The applicant managed to pass the outer fence and remained on the inner fence for 9 hours on the fence, before he was brought down by Guardia Civil, the Spanish border guard, injured by razor blades devices on the fence. So he was injured sitting 9 hours on the fence, and then he was taken down by Guardia Civil. He was escorted back to Moroccan territory through gates. So he did not reach Spanish territory. You know the setting, there is a double fence around this, a first fence, and there is a borderline in between, without any belonging neither to one or the other. Then you have the second fence, and then you have Spanish territory. So he was at the first fence, and then he was picked up by Guardia Civil and then brought back. The other applicant, there were two, entered the outer fence, climbed down again because he was injured, and was brought to American territory by American authorities. So he did not even reach the intermediate zone, where he was beaten after an escape attempt. Both applicants did not receive medical aid before handed over to Morocco, but later in Morocco. So neither by the Guardia Civil nor by the Moroccan police officers, but later on in the American territory. So the decision, interestingly, in this case, the court established that there was no violation of Article 4, not of Article 3. By the way, this is not my topic. I refer later. Article 4, Protocol 4, and Article 13 in conjunction with Protocol 4. Here, the situation was not new at the Spanish enclaves. So we already had jurisprudence on this setting, so to say, in ND and NT from February 2020. And the court in this decision, here it was of the third section, the one, but the ND and NT was a grand chamber this judgment. So the court referred to this, and the previous judgment from February was related to the situation in Melilla, the other enclave, Spanish enclave, but now we are in Ceuta. So, but they described it more or less as the same situation. And then the court assessed against Article 3 of the convention. And recalled the principles and established that there was no violation of Article 3. And then again, he referred to ND and NT versus Spain, that the applicants did not make use of any existing procedures for legal entry. And so there was no violation of Article 3. This was all assessment of Article 3. And only later in the paragraphs 22 following, the court established that there was also no violation of Article 4, Protocol 4, because the applicants themselves placed themselves in jeopardy by their own actions, by participating in the storming of the border, taking advantage of the group's large number, the size of the group, and did not make use of existing legal procedures for lawful entry. And by this caused the lack of an individual removal decision. So it was their own fault, the court said. They could have used the formal entry, the ways of formal entry, but they did not. So it was up to themselves that an individual decision could not be issued. And finally, there's no violation. So I call this the Spanish setting. So in the previous case, in the Hungarian-Serbian setting, the court, at least the section, it was the first section, here it was the third section. The first section was really very narrow, looking at one day, saying only at that one day there was a violation. But here it is a much wider scope, saying, and even if it was like this, it was the own fault of the applicants. So what is new? Interestingly, something new with regard to Article 3, that's why I mentioned it, which is not my topic, because the distinction between the accessibility of medical treatment and the violation by direct action of each of the authorities, the Spanish Guardia Civil and the Moroccan. So there are some new elements, I would say, but regarding Article 4, Protocol 4, provision of collective expulsion, there are no new elements, so to say. It's really referring to ND and NT and this element of self-caused problems, to say, in not using the official ways of entry and applying for protection. Finally, the case ANA and others versus North Macedonia. The applicants, 5 Syrian, 2 Iraqi, and 1 Afghan national, alleged pushbacks to Greece from the North Macedonian side. We are again on the Balkan route, so to say. And after the police and army officers by police and army officers after they illegally crossed into the territory of North Macedonia against the background of the migrant crisis in 2016. We know all about this March of Hope, where a huge number of people by foot were walking on this Balkan route. The Syrian family reached a point where at least 500 refugees were allegedly surrounded by North Macedonian, Czech, and Serbian military personnel in the territory of Northern Macedonia. So they have crossed the border and they reached this point after spending the night in the open air. So they were captured there, these 500 people in the open air after the night. They were threatened with violence unless they returned to Greece. And in a small village, soldiers of North Macedonian allegedly ordered to the other applicants to board army trucks and drove back to the Greek border, where police officers had been standing guard at the border fence, and where they violently were forced to pass the border through a hole in the fence. So imagine the situation: border fence, hole in it, a line of police officers left and right, and the refugees were pushed back through this hole in the fence. So this was the situation here. Interestingly, the court established many other facts regarding the general situation of border crossing to Macedonia, to North Macedonian territory. It is described here, I won't read it out. So there were several official points to enter Macedonia, especially the 2 airports, and 19 other border crossing points on the outside outside border of Macedonia. And there were a lot of protection applications registered in this time. You can see a huge number. It ended up at some time at 10,000 applications a day. You can imagine why the court established this, because later it refers to that there was a possibility to file a protection application. So what was the decision? April 2022, no violation of Article 4, Protocol 4 in this case. The removal of the applicants from Macedonian territory, forced return to Greece by members of police established, has to be regarded as an expulsion. Okay, again, so expulsion is easy. It ends up easy to an expulsion, just the fact when you take the people and push them out of the territory. Again, here the reference to ND and NT, the self-caused problem, so to say, by not using official entry facilities. So the court recalled the Spanish setting, so to say. A lack of individual removal decision justified by the applicants, by their own conduct, the court asked itself, and applicants circumvened an effective procedures for legal entry. So this was the scale, the Spanish setting scale, and nothing in the case file to suggest that potential asylum seekers were in any way prevented from approaching the legitimate border crossing points and lodging an asylum claim for the applicant's attempt to claim asylum at the border crossing and were returned. And it was the applicants who placed themselves in jeopardy by participating in the illegal entry onto Macedonian territory. Hence, the lack of individual removal decision was consequence of their own conduct. So here, the Spanish jurisprudence on the Spanish situation was transferred to the Balkan route. Interestingly, you can see the situation is very much like the first case, HK versus Hungary, more or less, but a completely different approach. Here it was the second section. Was all of these three are no grand chamber decisions. Hungary, the Hungarian-Serbian case, first section, Spain, the second section, and Macedonia, the third section. So what are the new elements? As you can see, the same line like in ND and NT versus Spain, the lack of individual removal decision had thus been consequence of the applicant's own conduct, notably their failure to use official entry procedures, which is in itself sufficient to complete that there had been no breach of Article 4, Protocol 4. But interestingly, there seems to be, to my point of view, an additional subjective requirement in saying it was their own fault. The respondent state provided genuine and effective access to procedures for legal entry, and that the applicants did not have cogent reasons for not making use of these procedures. So now, in addition to the usual way, it was their own fault that they did not use official ways, but now they have to present cogent reasons why not making use of this way of entering the country. Paragraph 121, the court is not persuaded that the applicants had required cogent reasons for not using the border crossing point at the material time with a view to submitting reasons against their expulsion in a proper and lawful manner. This would indicate that the applicants had indeed not been interested in applying for asylum, but rather in transiting through, entering or crossing the border. Interesting. So I would say the new element is this, the provision of cogent reasons, which seems to be required by the court. So here I have some points for discussion, but before entering this, I will stop my presentation. And please feel free to ask questions, and I'm very happy if you would like to enter into this discussion. Thank you very much.